get in civil cases, you get restraining orders now since you're doing private practice, correct?
Right.
What percent was in the civil, the probate, where you did these restraining orders? Did you represent the female as opposed to the male? I'm trying to get a sense. Are you 80-20, 50-50? Who do you represent?
In my 5 years of private practice, I recall representing clients in 3 restraining order hearings. One of them was a woman in probate court, and two of those cases in civil court, in district court, where a man was representing him as a defendant in restraining order.
So, in your 3 restraining order cases, 2 represented men as defendants.
Yes.
And 1 represented a woman as plaintiff. So, for all those that goes to this gentleman's point where, again, not my point, that most of these people who look for restraining orders are in fact women. So in this case, in your 3 cases, the people looking for a restraining order were in fact women.
Yes.
And again, you feel, give me a sense. I'm a lawyer, I don't go to court. You go 3 to 5 days a week. I go once every 20 years. I don't go to court. But give me a sense, how difficult is it to get a restraining order, whether you're a man or a woman? You go in, expire, and get a restraining order. Oh, it's very difficult. Oh, it's real easy. You give me those things.
Well, in terms of I think there's 2 issues. There's the ex parte order.
Well, let's do that one first.
Okay. Well, in the ex parte order, I've never represented a plaintiff there, or obviously a defendant, and they don't know about it. But there's the plaintiff, the person seeking the order, has to show to a judge that there's a substantial likelihood of being harmed, and that person would have to fill out an affidavit.
I'm familiar with that. But anyone could put, I went home tonight, and my wife, my husband, doesn't matter who, threatened me with, said he's going to beat me up and throw me down the stairs. I understand that. I'm just curious. Not even your own cases. You must have some. You must have some friends. You must have talked around the courthouse. This is your field. My personal injury. I got a good opinion of what cases are working, how I don't handle these cases. Give me a sense. I'm going to make it really my sense of talking to people, whether it's a man or a woman. It's extremely easy to get an ex parte restraining order. Do you agree or disagree?
Again, I don't know how easy it is to get an ex parte.
Okay. So you have no opinion.
Right.
Okay. Do you have an opinion, not only in your cases, but you must talk to people? That's, I think, the surprising. What do your friends say? What do you when it's not a fight? Now there's.
But I know. I don't know about people who are calling me or restraining order calling me what they expect to do. In terms of a final order in a 10-day hearing, a judge there has to evaluate the evidence and determine if the jurisdictional elements are met. As you know from a reading of the statute, sometimes the jurisdictional elements are fairly easy to establish. And then in a hearing, the judge has to evaluate the evidence and determine if real abuse has occurred. How easy is it on a general basis in the whole Commonwealth? I don't know.
And just where you practice, in your area?
In my practice, in my area, I have seen that the judges are very careful about listening to the evidence in a hearing. And they'll give both parties and even opportunity to present evidence. Oftentimes the parties are pro se, they don't have lawyers. And I've seen that judges take these matters seriously, and they give leeway to the fact that the parties don't have lawyers, and they make sure that the parties have, for example, the defendant has read their affidavit of the restraining order plaintiff, so the project damage can occur. And I've seen that for the most part. I think that the judges evaluate the evidence under the standard that they're supposed to do that. I think perhaps in the early days of restraining orders, they were issued more routinely, where, and I say this almost anecdotally, where it seemed like if the bare bones of an affidavit and the abuse showed that was to the judge that was what had occurred, then a restraining order would issue. I have seen, I think, in the past 17 years of more careful of their decisions regarding the evaluation of the evidence. I guess I would say that.
Okay, so I'm not really sure the answer, but